Law. Yeah. I was looking here at this. They call it a render a judgment, to pronounce or give forth a verdict or decision. Yeah. Rendering a decision, the giving forth of a judgment by a court. Yes. Now, in the court instructions, it says that the court, based upon the record, renders a decision. Yeah. Now, hang on here. I'm trying to find these instructions again. Yes. Now, hang on here. Now, if you look at this, okay, the protection, the court finds based upon the court record. Now, the judge, okay, is rendering a decision. Now, it also says the judge can grant, deny, or change any provision you write in this order. That means that the protection provisions are changeable because the commissioner or the judge decided that they disagreed with what the petitioner wanted. Now, let's say you issue a protection order where the petitioner doesn't sign it. Yes, and I was not given notice or opportunity to be heard. And there are forgeries on the document. Yes. And you issue it when there was no actual notice of the hearing, and I was not present, and the order was not issued in accordance of the full faith and credit provision of the VAWA. Right. And then you go ahead and you decide you're going to make the decision to issue it for 10 years. And then, instead of removing it once I informed law enforcement that it violates my 5th and 14th Amendment due process rights, you decided, no, you're just going to continue to enter it into the nationwide National Crime Information System because you must complete a law enforcement information sheet, the LEIS, Form WPF, all cases. This form does not go in a public court file, is not served on the respondent. It's used by law enforcement to locate and identify the respondent when serving documents. It's also used by law enforcement when entering the order in the statewide database. Now, when I email sheriffs in other counties and other states, and I know that if I was to move there and I got arrested for whatever reason, they do have the jurisdiction to enforce any court decision, any judgment rendered by any commissioner or any superior court judge or district court judge that is entered into the Nationwide Criminal Information Center, the FBI's database of protection orders. Now, when they tell me they don't have jurisdiction, well, they have jurisdiction to enforce it if I was to live where they're at. And when I inform them that they're enforcing what is an illegal court decision that was rendered not based upon the actual law's requirements, but based upon some sort of prejudice, it seems inhumane to continue to deprive me of my constitutional rights. Now, I'm quite serious about suing every sheriff in every county, every undersheriff, every police chief in every city, every police officer in every police department in every city, that if they were to ever stop me for whatever reason and wanted to know if there was any warrants for my arrest, if there were any court orders against me, they could look up on the NCIC and could see a protection order that was issued when there was no legal right to issue it. Now, they have the jurisdiction to have it removed because they're enforcing what is an illegal court document. So for every mandatory reporter that thinks that my sons are not missing and abused when they issued a protection order 6 years ago where I was not given actual notice and opportunity to be heard, and it was entered into the statewide database, as I have informed law enforcement. I'm very serious about suing every mandatory reporter that refused to contact law enforcement about my sons being abducted because of the abusive process and the abusive power of those in the county. Now, I'm going to want the law enforced today, and I'm sure that for every elected and appointed oath of office that knows that my constitutional rights are being violated and they would not enforce what they have sworn, I will sue every elected representative and senator in the United States Congress.